There's going to be two sides that are arguing and presenting evidence at Sean Combs' trial, so why not kind of do a preview of that? It is time to debate the Sean Combs criminal case, and we have former New York federal prosecutor Berit Berger representing the prosecution, and renowned criminal defense attorney Brian McMonagle, who represented Bill Cosby. He will be speaking for Combs' defense. Let's debate it out. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. For the past 5 weeks since Sean Diddy Combs was arrested, we have talked about all different aspects of this case. We've talked about the federal indictment, we've talked about the charges, the potential witnesses, the victims, potential plea deals, filings from the prosecution and defense. We've broken it all down, but one thing we haven't really done in depth is actually debate the case, debate the evidence in the case, to be more specific. What will be the arguments back and forth? Well, that is what we're going to do right now. And we have two great guests to do it. So remember, Sean Combs, he currently sits in the Metropolitan Detention Center in Brooklyn after being denied bail twice. This as he awaits trial, which is currently scheduled for May of 2025. We'll see if that date sticks. And it is there where prosecutors will try to prove beyond a reasonable doubt to a jury that Sean Combs is guilty of racketeering conspiracy, sex trafficking, and transportation to engage in prostitution. In other words, that he used his businesses to further a criminal enterprise that was engaged in forced labor, kidnapping, bribery, arson, sex trafficking, that for years he sexually assaulted women, forced them into elaborate sexual performances known as freak-offs with male commercial sex workers, that drugs, violence, threats, coercion, they were used to get people to comply. As we're talking the law today, one of the things I have to say I really enjoy doing, and doing it here on Sidebar, is talking about big legal rulings. And I got to tell you, I have quite a landmark one for you that has just changed things in a very big way. You can now legally trade on who will win the 2024 election. Yes, legally. And that's because our sponsor of Sidebar, Kalshi, they went to court and they won legal approval for election trading for the first time in over 100 years. And not only can you essentially bet on the 2024 presidential election winner, but with Kalshi, you can bet on who will control the House, the Senate, who will win the swing states, so much more. You think that's timely right now? And it's not just politics, by the way. You can bet on other future events too, like will Taylor Swift win Top Artist on Spotify this year? What will be the Rotten Tomatoes score for upcoming movies like Gladiator 2? Actually, I think it's going to do really well. I say above 85% personally, but there is so much more. You're going to be like, wow, I can trade on that. This is the only place to trade on events like this in all 50 states. And you can sign up right now using our link kalshi.com/sidebar, or you can scan the QR code on screen. And if you're one of the first 500 traders who deposit $100, Kalshi will give you a free $20 credit. That's kalshi.com/sidebar. Now, the defense obviously has a very different take on this, but what is that defense? What exactly is the prosecution's argument? Well, rather than having me explain both sides, we are now going to debate this out. We're going to discuss this. So I had the opportunity to sit down with two brilliant legal minds to debate the evidence in the Sean Combs case, a good preview of what we may be able to see, what we may expect in an upcoming trial. Let's take a look. So it is debate time, and we're going to have a debate on the Sean Diddy Combs federal case. And it's not just because I have this gavel and I wanted an excuse to use this, although I really don't know why I don't use this more, but it's fantastic. I will be using this. But I am joined now by my two special guests. So to represent the prosecution in this case, we have Berit Berger, who is the former Executive Assistant District Attorney for Policy and Strategic Initiatives and Chief Ethics Officer for the Westchester County District Attorney's Office. She also served as a federal prosecutor in both the Eastern and Southern Districts of New York and teaches at Fordham and Columbia. Am I right, Berit?
You got it.
Okay, so this is our prosecution. Great prosecution. Only now to be matched for the person who will represent the defense in this case, Sean Diddy Combs. We have premier criminal defense attorney Brian J. McMonagle from the firm McMonagle, Perry, McHugh, Mishak, and Davis. He famously represented Meek Mill, Bill Cosby, who helped obtain a hung jury in his first criminal trial. Brian, great to have you here as well.
It's great to be here. Thanks for having me.
Okay, you guys are both really, really nice, but we will see how this goes. This is going to be a very, informal, fun back and forth about this case. I am going to lay out, I'm going to have each of you lay out your opening statement. It doesn't. I don't have a podium. I don't have a fake jury. This is not a mock trial, but your best opening statement for this case. So Berit, I will start with you. For the prosecution against Sean Diddy Combs, what would be your opening remarks?
Very hard without the podium in my notes.
Do you want the gavel?
I kind of do want the gavel, but I fear that I might get excited and throw the gavel.
Yeah.
So as the prosecutor in this case, I would probably start by saying, ladies and gentlemen, this is a case about power and how one man, Sean Combs, used his power, his influence, and his wealth to abuse, manipulate, and violate women for over a decade. During the course of this prosecution, you will learn how Sean Combs used his power to recruit women, to use force, fraud, and coercion to manipulate these women into engaging in commercial sex acts for his own satisfaction. And he didn't do this alone. He was enabled by an army of staff, security personnel, personal assistants, other employees who helped find these women, who helped organize these drug and sex-fueled encounters that Combs called freak-offs. And significantly, they helped cover up these crimes, bribing witnesses, trying to coerce people not to tell their story, and trying to obstruct justice and destroy evidence. You will learn about the ways that Combs got these women to do what he wanted them to do. He would sometimes dangle carrots. He would offer them career opportunities, financial security, romantic relationships, and then he would threaten to take those away if they didn't comply with his demands, if they didn't engage in commercial sex acts for his enjoyment. You will learn he also used violence. He used drugs. He is many instances where he hit, kicked, punched, threatened, used guns to threaten his victims, all enabled by the rest of this criminal enterprise. And at the end of the day, after seeing this physical evidence, after hearing from many of these victims, whose stories will be corroborated by thousands of pieces of documentary evidence, by electronic evidence, all of the stories that they will tell you will be backed up by this evidence. And at the end of the day, you'll learn that this is not a case about somebody's sexual preferences. It's not a case about sexual preferences that may be different than yours or mine. This is a case about abuse and how one person took advantage of his powerful position and his incredible wealth to manipulate, abuse, and violate women.
Wow. Now, I should tell everybody, Berit was not reading from a script there. That was all straight from her head. So very, very impressive there. And just to let everybody know, this is a little bit difficult for us to do since we don't know all the evidence. We don't even know who the witnesses are. We don't know who the victims are. We can surmise what maybe some of the digital evidence is, but we're doing our best we can. So that was great. That was the prosecution's opening statement. Brian, counsel, your response for the defense.
Well, ladies and gentlemen, thank you for taking time from your lives and your jobs and your families and embracing what I consider to be one of the most important aspects of American citizenship. You took an oath today, and it might be one of the most important oaths you've ever taken. I listened for a little bit as my able colleague set forth her case, and I want to make it real easy on you. My client is guilty of many things. He's guilty of coming from nothing and ascending to be one of the greatest entertainers of our time, and then going beyond that and becoming one of the great entrepreneurs in this country. He built businesses. He created fashion lines, television companies. I could go on and on and on, guilty of that. He's also guilty, quite frankly, of engaging in a social life that lacks morality, as you and I know it, including sexual promiscuity, including drug use, things that you or I would never do. He's guilty of that. But you took that oath here today not to decide whether or not you agree with the way he lives his life. No, you took an oath to decide whether or not he committed crimes. So let me make it easy for you. Fact. My client never sexually assaulted anybody. Fact. My client never kidnapped anybody. Fact. My client never compelled anybody to do that which they did not want to do. I heard my colleague talk about carrots, and it's interesting that she would bring up carrots because these folks came for the carrots. They came to these parties like many came to the parties of Hugh Hefner and all these folks who live these kind of lifestyles with their eyes wide open and their hands open to be paid in some instances for sexual activity, to receive gifts in many instances for sexual activity. And while you and I will walk away from this courtroom, believe me, feeling a little less clean after all the things we've heard, when you walk away from this courtroom, I assure you, if you hold the government to the highest burden of proof of any court anywhere in the world, you will conclude that my client is guilty of many things, but none of them are the crimes charged in this indictment. Do me a favor, keep an open mind, make sure once you hear a witness testify, you listen to what they say on the direct examination, and then wait till I get a chance to ask a couple questions of my own before you decide whether or not they're telling the truth. And also put in the back of your mind one thing. Have they come here today for justice, or have they come here today for money? Pay attention to the lawsuits that are pending against this man. Pay attention who's bringing these lawsuits, and you tell me who came here for carrots and who came here for justice. Thank you.
Now, do you see why we had Brian and Berit here? This is phenomenal opening statements from you both. And now I want to go into, this is almost going to be, I guess, moot court a little bit, but I'm going to be posing questions to both of you guys. So Berit, I'll start with you. Something that Brian had mentioned is the idea of whoever's called to the stand, whoever are going to be these witnesses, these accusers. Presumably, you have to imagine Cassandra Ventura may be a key witness. That's an issue about what their financial incentive is to come forward. Them come forward at this point in the game of sometimes allegations that could be years old. How do you address that?
Yeah, I mean, it's going to be one of the challenges for the government, but it's not unique to this case. This is a challenge the government has in a lot of cases, right? You don't pick your victims. You don't pick the people that ultimately were the ones violated by Combs. He picked his victims. He's the one who went after them. Lots of victims come with their own baggage. Either they have, tricky things in their past that they're going to have to account for when they're testifying, or they have complicated financial incentives like they might if they had filed a civil suit. So we see this in a lot of cases. It's definitely something the government has to deal with. The way they'll deal with it, number one, they're going to be upfront about it. They're going to disclose all the information that they have about any potential incentive that the witness might have to not testify truthfully. That's called giglio material. So they're going to disclose that. They're probably going to front it in the direct examination of the witnesses too. They're going to say, look, you filed a lawsuit here too. You are trying to get money. And the more upfront the witness is, the more credibility they will have. I think the biggest tool that they're going to have in their arsenal about combating the argument the defense will make that these are just financially motivated cases is all of the physical and other documentary evidence that they're going to have to back up the witnesses' statements, right? Because while you can say, a witness might be coloring the truth, a document doesn't lie. And an email that they recovered from his phone or text messages that they got from a server, those don't lie. So that's, I think, what they're going to have to rely on to back up the stories of what the witnesses are saying.
And Brian, I'll give you an opportunity to respond to that. And let me couple that as well. I imagine an argument could be, well, the laws changed in New York. The Adult Survivors Act, the gender Gender-Motivated Violence Act, basically, these laws allowed it a look-back window for people to file a lawsuit for claims that were otherwise too old. And because the law changed, maybe that's why you see a Cassandra Ventura coming forward this time later. All of these people felt emboldened by the people who came before them who filed lawsuits. So if you're going to be saying, there's a financial incentive, they're coming for a payday, that could be the counter-argument. So I'll push it back to you in terms of the credibility of these accusers. You heard what Berit said, and you heard what I pushed back on.
Yeah, Berit's not wrong at all. I will say this. I think the only way to succeed for the defense in this case is to try to contrast it. Berit's right, as a prosecutor, you don't pick your victims, but you do pick your witnesses. And I think the defense has to make a case here that what these folks are doing and portraying themselves as victims is an insult to everyone who's ever been a victim. And I think you have to say that. You have to acknowledge the fact that day after day after day throughout this country, people are victimized in horrible ways, young, old, everybody in between. But that's not this case. This is a case where people came in with their eyes wide open. They came to sex parties to have sex. They came to sex and drug parties to have sex and drugs. They didn't come there for any other reason, and maybe to see a few celebrities and partake and to have some fun. But the folks that are testifying here in this case are not victims. And what they want at the end of the day, whether they would have brought this lawsuit 1 minute after it happened or 10 years after it happened, they never brought it. And the only reason they're bringing it now is for one thing and one thing only, and that is to keep the carrots coming. And I think that's got to be it's a difficult task for the defense once you have multiple victims. The contrast in the two Cosby trials told you that. The one case I had, we only had, I think, one additional victim and some mention of two. The second time they tried it, there were 4 or 5. And, it could be death by 1,000 cuts for Diddy if there's a lot of victims, real victims, and folks that can portray themselves that way.
See, here's the thing, Berit. When you think about the freak-offs, which are the central core allegation of the indictment, the argument could be group sex is not illegal. Drug use, yes, is illegal, but they're not going to charge him in a federal indictment like this for having drugs. A lot of these people, Cassandra Ventura said in her lawsuit she was tasked with calling these sex workers, organizing the parties. Sure, she could say she was under force, she was under coercion, but is the jury going to believe that? Don't you think it might be hard to prove that these freak-offs, although wild and bizarre, are they necessarily illegal? How are you going to prove that that's evidence of racketeering, that that's evidence of sex trafficking?
I think there's a few things. I mean, first, the one thing that I would push back on what Brian was saying is I really think, you said maybe one of the reasons that victims have come forward for these lawsuits is because there's been change in the laws. In addition to changes in the laws, I think there's been a change in our collective understanding as a society about how power dynamic affects these consensual sexual relationships, right? As we saw with Harvey Weinstein, as we've seen with, many different powerful men who have been accused of using this power to essentially coerce people into sexual relationships. What we tend to think of as, equal footing, consensual relationship to adults, that power, the wealth, can really impact those relationships. So there has been changing societal attitudes in addition to the change in the law. Now, to your question about how do we show that these freak-offs were something criminal as opposed to just, crazy sex parties that people are entitled to have at their discretion. I think what the prosecution is really going to have to show is, number one, that the way that these victims got to these freak-offs was potentially under fraudulent circumstances. Either they didn't really know what they were going into, they felt coerced to going into these, and or that once they were there, they couldn't leave, right? Because they were given drugs, because there was threats made to them, either physical threats or threats to take away some sort of resource or financial opportunity, something like that, that made it very difficult for them to stop at any time, right? Because when you think about what's the hallmark of a consensual relationship, one, you know that you want to be there, and two, you can leave whenever you want to. And if they can show that either of those two elements isn't present, then they're going to have an easier time convincing a jury that this was something criminal as opposed to something just devious.
I agree. I think that's more of the fluid kind of charge there, and one that's open to debate or open to argument from both sides. But I will tell you, Brian, I think where the defense is going to really struggle, and I put it back to you on this one, is the transportation to engage in prostitution charge. For me, that feels incredibly straightforward for prosecutors to prove. Were these people sex workers? They'll say, oh, yeah, I was a sex worker. Were they paid by Combs? Yep. Were you transported to places where Combs was, hotels, houses, to engage in commercial sex? Yep. That one, you don't need force, you don't need fraud, you don't need coercion. It seems pretty straightforward. How do you defend against that specific charge, which I believe carries 10 years in prison?
No, That one doesn't
Yeah,
have a
I don't.
mandatory minimum.
That doesn't have,
Yeah,
I thought it
they're-
had a mandatory minimum.
No, the sex trafficking does. The Mann Act charge doesn't have a mandatory minimum.
Oh, interesting. I guess it's being. They said 10 years, but you know better than me. Okay, but how many years are you looking at for
So
transportation?
that would be a maximum of 20 years. So there's not a mandatory minimum for just the prostitution. For the
Okay.
sex trafficking count,
correct.
10-year mandatory minimum.
Correct. Okay, great. So, but even now,
I think you've touched upon it. I think you know what the defense is going to have to do once they get all the discovery in this case is decide what hills they want to die on. They may want to embrace an approach that says, hey, listen, yep, here's what I did. I did transport prostitutes across state lines so we could have sex parties, and take one in the chin there. The guidelines on that probably aren't nearly as bad as everything else. You avoid the RICO, you avoid most of the harsh charges in this case. And so you may see that, and I've done that a lot in the past, and sometimes with some measure of success, because the jury, most juries want to give you a little something. They don't want to give you everything. One of the things that Berit said that resonated with me a little bit is how, in fact, the way that the pendulum has swung in this country will affect this case. Because we saw it in Cosby. I mean, Cosby, we were right there in the middle of the movement. And that is going to affect, I think, jury selection in a huge way in this case. Because there are a lot of people of my generation who really, feel like the pendulum swung a little bit too far. And those are going to be the people you're going to be targeting during jury selection, because it's really kind of important, because Berit's right. If you look at this through the lens of how we look at these cases today, that people of power take advantage of their station in life, their wealth, et cetera, to take vulnerable victims and make them victimized time and time again. People look at life that way. He's going to be in a world of hurt. You got to look at those jurors that are more conservative in nature, who are going to question why somebody shows up at a sex party to begin with, why somebody voluntarily consumes drugs in a setting in which sex could be the next option. Jury selection here is going to be huge. It is in every case, but it's really going to be huge here.
I want to take a specific piece of evidence that I will say is arguably one of the most important pieces of evidence, and see both sides to this, the prosecution and the defense. I'm talking about the 2016 videotape that was published by CNN several months ago that purportedly shows Sean Combs beating Cassandra Ventura in a hotel hallway. It is a savage, disturbing video that Sean Combs apologized to in an Instagram post 2 days after. And we knew that this was going to make its way into this indictment, and it has. So for the prosecution, talk to me about that video. Talk to me about what relevance that video has and how you would present it.
Yeah, I mean, the prosecution clearly thinks this is an important piece of evidence too. You know that because they referenced it in their detention memo, right? This was one of the things they used in order to convince the judge that he shouldn't be given bail, saying, look, we actually have this, you can see for yourself how violent he is. You can see for yourself what he does when someone tries to leave one of these sex parties. I think this is like example of what I was talking about, is how they combat that narrative of, oh, these were just, everyone's there for a fun time. Everyone, was there as consenting adults. This is what they point to. This is what they say is, she was trying to leave. She was literally trying to leave to go to the elevator, and this is what happens. Then I think they show what happened after that, right? The efforts that were taken to try to convince her and probably many other victims not to go to the authorities, not to share their story. The evidence that they can point to saying, look, they even went so far as to try to get the hotel to take this off the server, so we didn't have this, right? What does that show? That shows consciousness of guilt. That shows that they know that this was something that was not consensual, that this was something that was criminal and that they needed to be worried about. So I think this, I'm assuming there's probably other pieces of, electronic evidence that they could point you to, but this, to have that on video, you usually don't get something like that. So I think that's going to be pretty critical.
Brian, how do you fight against that video? Is there another context you could put that video in?
Well, it's a horror story for the defense. I think what you're going to see is a very aggressive challenge to that video. I don't know what the backdrop of that particular domestic violence, on tape was. Did it happen in connection with one of these parties, with one of these other charged pieces of the indictment, or was this just a situation between two individuals that are in a domestic setting where he clearly engages in a horrible assault. That'll be the subject of significant pretrial motions to keep this out of the case. And a judge is going to have to balance whether or not it has any probative value to the charges involved in this case. And if not, it could be excluded. If it's in, and we're going to make the assumption that it's in as evidence for purposes of your inquiry, you're going to have to start right from the very beginning, owning it. You own it. You as a lawyer, separate yourself from your client on that one and acknowledge that it's horrific. It's unspeakable. He's guilty of that, but don't find him guilty with the other stuff that they've charged him with. You can't, you can't get around a video like that, except to simply put it aside for purposes of the other charges. Again, what hill are you going to die on? If that video comes in, if there's a charge count that includes that specific act and that horrific conduct, they're going to take it on the chin.
Yeah, and look, to be clear, that's what it seems his defense counsel is already doing, saying that this was some sort of domestic spat. The problem with that is apparently the government will say we have a witness who was in that hotel room, the one that Sean Combs ran out of wearing the towel, who says he was a sex worker and that this was a freak off and she was trying to escape from that. And so it'll be interesting to see both sides. I will start with you on this, Brian, though. When I've talked about this case, and I think this is something the defense will exploit, and then I'll move it over to Berit on this. Whenever I try to explain the racketeering charge, the racketeering conspiracy charge, what the elements are, how to prove it, talking to people who are not lawyers, they get very confused by it and what exactly Combs is accused of with respect to this charge, which I will tell you, it makes up 80% of the indictment. It's a big part of it. So what would be the ways, your defense counsel here, what would be ways to strike it that there was no racketeering conspiracy?
I think it's pretty easy. I think that's the best part of the defense argument in this case. Most jurors walk in there with the belief that RICO is, it's Michael Corleone and everybody else. It's mob oriented. It's drug organization oriented. It's not an entrepreneur who throws sex parties. Was Hugh Hefner part of RICO? And I think you got to kind of appeal to that simplistic version of RICO. The problem you have from the defense is once they start reading the elements of the crimes during jury instructions and start marrying them up as the government will do, they certainly will have a compelling case to say, well, we checked every box as it concerns RICO. I still think, though, that there is a real effective way to beat the RICO in this case. I just do. Prosecutors for decades have used RICO and expanded it, and well, they should, because, take what you can get. But I think sometimes they bite off more than they can chew with RICO, and I think they may have done that here. This isn't organized criminal activity. This is, a successful businessman, an entrepreneur, an entertainer who just has a show of a social life and has probably committed some crimes in carrying out that social life, but he's not a racketeer, and this isn't racketeering.
Berit, your response?
Yeah, I disagree. I probably am one of those prosecutors that Brian's referring to that has expanded RICO beyond where he would want it to. But as I look back at RICO cases that I charged and prosecuted, they were far less organized and far less well-defined enterprises than what we see here, right? Combs really had, he was the enterprise. It was his name all over the businesses. And what I think the prosecutors are going to have to do to convince those who may not want to be convinced that this was an enterprise is show that he used those businesses. He used the resources that they had. He used the platform that they gave him to effectuate these crimes, right? It can't be something separate. It can't be he was a businessman and he also was engaged in criminal activity. It has to be he, as Sean Combs, the enterprise, used this very thing to enable him to do these criminal acts. So how will they do that? They'll show that the people that were working for him as a part of his business enterprise, those were the people that he was using to help recruit women, to help facilitate the freak-offs, to help cover up criminal activity that happened at the freak-offs. He'll have to show that those people were both enterprise workers and also sex trafficking enablers. So really tying those two things together is going to be pretty critical for the prosecution. But I think I mean, once, like Brian said, once they hear the legal elements of what a RICO is, about what an enterprise is, what the conspiracy is, I think they're going to understand that that's exactly what this is. And as soon as they make that jump, this is such an incredible tool for the prosecutors because it enables them to bring in all these otherwise perhaps unconnected acts to show that over a decade here, a long time span, to show that they were all done in furtherance of this enterprise, right? He used the enterprise to help him do this, and each of those things helped just further the enterprise and what the enterprise was trying to do. So I think they're going to be able to connect the dots on that.
Brian, I'll give you an opportunity for a quick rebuttal if you're interested.
I'm going to tell you something. If he worked for IBM and he was doing all this stuff, do you think it would have been charged as a RICO? And that's what you got to be able to argue to a jury. Come on. He has a legitimate business organization. This isn't a criminal organization. The organization is one of the greatest business enterprises in the country. While engaged in legitimate business enterprise, this guy went off the grid socially. It doesn't make it a RICO. RICOs are for criminal organizations, not people who are involved in legitimate organizations who engage in misconduct. They've overcharged it. They should have charged him for what he did and not for what mobsters do. And that's the retort.
Okay. I could have this debate a little bit more, but I was looking at the time. I know we have to end soon. So I want to go to one final issue, the issue of bail, right? So Combs was denied bail twice. He was appealing it to the Second Circuit, has actually asked them to pause it so that he can argue the issue of bail to a third judge, the judge that's now overseeing this case, Judge Arun Subramanian. I'll start with you, Berit. So for the prosecution, why do you believe that Sean Combs deserves to be locked up, should not be granted pretrial detention, should not be granted pretrial release, should not be granted bail? What's the argument?
Yeah, I mean, so first of all, just looking at the statute, so the sex trafficking is a presumption case, which is just a fancy legal way of saying that the presumption is that a defendant charged with this is going to be detained, right? So now it's up to the defense to show that there's something that they can offer that can overcome or rebut that presumption. So already we have a little bit of a leg up because it's a presumption charge. I think there's a few things really going for the government's favor in this. Number one, the severity of the charges. As we said, he's facing a 10-year mandatory minimum. 10-year mandatory minimum gives somebody an incredible incentive to flee, to obstruct justice, to try to do something to get out from under these very serious charges. Prosecution's also laid out a lot of the strong evidence in their case, including the video that we also talked about. So Combs can see right away how strong the government's case is going to be. Again, that goes to risk of flight. So when you look at the bail statute, there's two prongs that the government can argue detention on. One is risk of flight, right? He is a danger of not showing back up in court. The other is that he's a danger to the community. They've argued that the evidence is strong for both of these prongs. So we talked a little bit about risk of flight. This is a guy that has resources. He can, he had a private plane. According to the defense, he no longer has that private plane, but with millions and millions of dollars at his disposal, he could probably get another private plane. He could probably find criminal associates that could get him another passport or get him out of the country if he really wanted to. So this is a big strike against him, right? The second part of this is danger to the community, right? Even if he's on home detention, even if he has one of these, electronic ankle monitors and he can't leave his home, he is still a danger to the community. He's a danger that he might reach out to potential witnesses. We know he's done it in the past. This is not new conduct for him. He's already shown that he's willing to do that. We also know that a lot of the criminal acts that he engaged in were done, from his own home. We're not done out in public. We're done in secret. So again, I think based on both the statute, this rebuttable presumption that we have of detention, and how many different times Combs has shown that he is both violent and potentially obstructive, I think it's going to be hard for him to convince a judge to get him free on bond.
Brian, what's the other side? What's your response?
Yeah, I mean, the other side is simply this. He's presumed innocent of these charges. So in terms of determining whether he's a risk of flight or danger to the community, let's look and see if he's got a criminal past. And the answer is none. No prior record. Never in trouble before. Successful businesses. Intact family. Contacts in the community. The idea that they've put forward a bail package that will prevent him from going anywhere, talking to anyone, intimidating anyone and of course never leaving the country. They'll have him on a monitor. He won't be able to go anywhere. He won't be able to do anything. Listen, no one really believes that if this guy is released, he's going to start intimidating witnesses, because that would land him back in jail and about 17 additional counts onto his indictment. No, I think the problem he's got for himself at this point is that he's struck out twice already. And I think district court judges are very loath to overrule fellow district court judges who have already ruled on the subject. And I thought if he had any other shot, it would have been in the Court of Appeals, but we'll see.
Yeah, and that's, I think, he's trying to ask for that to be paused until he can try to convince Judge Subramanian. And apparently they've been indicating they might have new evidence to support their petition for pretrial release, so we'll see. Before I let you both go, can we agree on one thing? Maybe you agree. I have no idea.
No.
Do you both agree that Sean Combs shouldn't take the stand? I mean, or maybe maybe I'm wrong. As a prosecutor, you probably would want it. Brian,
Not with
can
Barrett.
you both agree or disagree?
That's for sure.
Yeah, you probably want it, but yeah.
I will say this to you. 99% of the cases, you don't want your client anywhere near a witness stand. There would have to be some compelling reason on some compelling count that would allow me to do that, particularly if that video gets into evidence in this case. But let me say this. If you ever put a client up there, it's one that's really smart, that doesn't have a prior record, that can't be impeached with a prior record. And it may be the kind of case where you don't have that choice. You've got to humanize him, because for the last month or two, he's been painted out to be the devil. And he might be the kind of guy that if he took the witness stand, because he seems like a charming fellow when he's not up to all this debauchery, he may be able to swing a juror or two. And that's all he needs.
I was so quick to say you both would agree. I forgot. Berit, it's a prosecutor's dream probably to have Sean Combs on the stand.
Yeah, it kind of is, to be honest. I mean, I fear that it is a dream that will not come true. I cannot imagine a scenario in which the defense would put him on the stand. I really can't. I mean, unless it's like Brian was saying, it's kind of the Hail Mary there. One of the biggest things that defendants have working against them when they want to testify, many defendants want to testify, I think it's very hard to keep their tempers in check, to keep calm on the stand, and very easy for a skilled cross-examiner to get somebody all roiled up. And that just backfires tremendously when a jury sees that side of somebody.
Well, you both were great. I didn't have the opportunity to even use this. It was less heated than I thought it was going to be. But I think we have a good sense of what some arguments could be. I'll tell you what. If you guys are both available, when new evidence actually is revealed in this case, would love to have you both back to talk more about it, because it was difficult, right? We're trying to make sense of what might be argued, and there is, of course, the possibility that we could see a superseding indictment with more charges, and we'll cross that bridge when we get to it. But Berit Berger, thank you so much for coming on. Really appreciate it. And Brian J. McMonagle, thank you so much for coming on. I really, really appreciate it as well. And you two are terrific. So thank you for giving the perspectives on both points.
Thanks.
Thank you.
How great were they? How great were they? Fantastic, right? Now look, truth is we don't know exactly what this case will look like. We kind of did a preview based on what we see, what we're assuming, what we're reading from the filings. But I think it was a good preview of maybe what to expect. And again, want to thank Brian and Berit for not only being so generous with their time, but my gosh, great arguments from both sides. I didn't even have to use my gavel. What are you going to do? Anyway, that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. As always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.